Hariharan, the founder and CEO of IDify, to understand more about the same. Before that, let me get on board Hariharan, who's joining us now. Hi, Ashok. Thank you so much for taking the time out and joining us today.
Yeah.
All right.
I'm really excited about the DPDP Act as well. So, yeah.
Right. Under the DPDP Act, the ministry has given companies 12 to 18 months to implement the various parts of the law. Now, specifically, companies will have 12 months to appoint consent managers. How do you plan to go about, reorienting yourself with the new law?
Yeah, I see. At IDify, we are essentially we have a consent governance platform which we call Privy, which fiduciaries can use to get compliant. The idea on the consent manager, specifically the question that you asked, is largely the consent manager is focused on the data principal and his rights, and he's a agent of the data principal. The way we look at it is there are two parts to the same puzzle. One is the data principals, an agent of the data principal, which is a consent manager, and what we call consent governance, which essentially the data fiduciary needs to put in place. Not only a consent governance, but also data governance. So we have to be very clear that this is a Privacy Act and not a consent act, right? So it is actually an act about data privacy and data itself, and not just about taking consent from the principal. So there's far-reaching repercussions for the fiduciary in how they manage data and how they get compliant there. And that's sort of what our product is focused on, is how do you make a fiduciary fully compliant and be ready for the DPDP Act itself.
Right. Also, companies will also have 18 months to implement a mechanism to seek express permissions from users before using their data for business purposes, such as targeted advertisements and so on. They will also require to inform the newly notified data protection board of data breaches within 72 hours and inform users about these without delay. What are going to be the challenges and cost pressures on the companies to implement this?
Okay. Now, if you think about a data breach, what could have breached, right? One is a fiduciary could be sending promotional messages to people that they did not take consent from. That is one type of breach. Second type of breach is actually a data breach itself. That is, your data got stolen either because of willful, fraud by employees or by a third party, or you got attacked. Now, when that happens, you need to now inform the DPB within about 72 hours that this has happened, and also have remediation on how did you fix this. Apart from that, you need to report, you need to send a notification to 4 people, right? One is the data principal, which is the individual who got affected, the data protection board, which is the board which is now going to be looking at the regulation and getting people, compliant. Third is your own sectoral regulator, which would be RBI, and what they used to do, which is certain, and all of them need to be responded to within a very, very short period of time, which means that you need to know the attack surface very quickly. A lot of times today, a lot of the companies don't even know what has been breached within that time period. So unless you put massive technology backend and processes for this, you won't be able to get compliant soon enough. And so what it really means is a people, technology, and a process transformation that an organization might have to go through, which will take time. And it is not just about getting a process compliant, but also about training people within the org. It's about implementing technology which allows you to look at data and the way data is used within an organization. Apart from that, you need to also think about how your third parties, for example, if you have a bank might have 10,000 third parties that have access to this data that is partners of theirs, and they need to be using that data properly as well. So you really need to start to also look at the impact assessment of risk specifically, and actually the DPDP Act also talks about yearly impact assessments now that will be which you will have to showcase to the DPP as that you are compliant. So this is quite a long, big remit for a bank. It does for a fiduciary. It won't be possible to do it quickly, but we have to go down that path at some point, and that's what everybody has to do, I guess. But more importantly, there is cost to it. But the way I think about it is the fiduciaries that do this first are going to build trust within the ecosystem, and that trust actually will generate revenue. So I think the way to think about it is not about cost, but how do you make this a core proposition for a fiduciary?
No, you're right, Ashok. But also, having said that, digital marketing that has picked up so much pace, in the last few years. In fact, that has almost trumped television media as far as ad spends are concerned. That is entirely driven on the proposition of targeted ads because of the data that these companies are sitting on. How will this impact digital marketing?
So if you think about digital marketing itself, there are three types, right? One is anonymized, that is based on what I'm searching. I'm shown something that won't have much of a problem because you don't have to necessarily take consent because there is no PII there. But the other type of digital marketing, which used to happen, which is you get an SMS. So that means that the marketer, has your email address or your phone number or things like that, that would need explicit consent going forward. So it actually kind of, or for that matter, if you're doing targeted based on my profiling that you might have done, that would need to fundamentally get my consent and depends on where you get my data from. So the whole change is going to come into, like, if you think about there were these data brokers who would sell data about individuals or even anonymize information based on phone number or address, etc. I think that's going to get a little more tougher for organizations to do. But the traditional, like, sort of the SEO oriented approaches, I think those don't change fundamentally. From a ad perspective, if you're doing targeted ads within like a Facebook, then Facebook would have to take explicit permission from me. But they have been doing that in GDPR world anyway, so it wouldn't fundamentally change for them. It's similar here.
Okay, so all the social media platforms and other parties that handle user data will also be required to appoint a data protection officer in the next 18 months.
That's
Earlier also, there has been a clamor for data privacy vis-a-vis social media apps like, Facebook was under a lot of flack because of that. What is going to change this time round, really? Because there has already been, so much of clamor about data privacy. Like I mentioned, Facebook was under scanner because of that. This time round, really, what is the change that will come about?
I think the big change is the fines itself. Now there is a board, there is a regulator, there's a board which is looking for compliance. Earlier, they would just get a slap in the hand, largely because somebody noticed it. They might get a small fine, if you may. But now with this act, I think it's a far-reaching act. It does put governance in practice. That is the DPO. There is a DPO who's answerable to the board. It no longer is sufficient that this is like compliance to privacy is an afterthought. It has to be part of the product now. I think in my opinion, there are regulated areas where it would get implemented first, where the regulator is concerned about this. For example, an RBI, a SEBI, an IRDA, etc. And unregulated or where there's no sectoral regulator, it might be a little slower. But I think they'll all be in that path of getting compliant over the next 18 months. And I think what will fundamentally change is that now there is a law for it. There are rules for it. Earlier, it was relatively vague. So that's sort of, one of the reasons that we also started this product was about this particular problem, right? The number of calls that you get from builders, for example, I get about 20 a day, where I have not given them permission to call me. They're procuring my data and using that, and they're probably procuring it from these social media, from these social sites, etc. And I think that's where our interest in it came from. And so it was a personal pain. And I think with this act and the rules, there is now a way for the citizens to get protected, not just as lip service, but actually in a way that makes the fiduciaries responsible for it.
All right, Ashok, on that note, we'll let you go, and thank you so much for joining us and weighing in on the DPDP rules that have just come out. With that, it's a wrap on this edition of Startup Central. I'll take your leave. Thank you so much for tuning in.